Hello everyone, this is Urvashi Chauhan. Welcome to Courts Today by Live Law, where we bring you the latest developments from all courts across India. Let us start. First of all, let me give you a brief of the Constitution Bench hearing on petitions challenging abrogation of Article 370 and revocation of special status to the state of Jammu and Kashmir. Senior advocate Dushyant Dave today continued to argue. He said that abrogation was a colorable exercise of powers because the BJP government in its 2019 manifesto had proposed the repeal of Article 370. That Article 370 had achieved its life and could therefore not be abrogated after the dissolution of the Constituent Assembly in 1957. Countering this contention, CJI Chandrachud said that the argument that the power to abrogate Article 370 ended with the Constituent Assembly's dissolution was contradicted by the constitutional practice because several constitutional orders were issued after 1957. Senior advocate Shekhar Napade also argued today and appraised the court that the abrogation had led to adverse consequences. For instance, Jammu and Kashmir does not have proportionate representation in the Lok Sabha, which amounts to a violation of Article 14 of the Constitution. You already know that the Constitution Bench hearing the matter comprises CJI Chandrachud, Justice S.K. Kaul, Justice Sanjeev Khanna, Justice B.R. Gawai and Justice Surya Kant. Today was the 7th day of the hearing. The arguments will now continue on Tuesday. Stay tuned with us. The Delhi High Court Women Lawyers Forum today sent a letter petition to the Chief Justice of India seeking action against videos circulating on social media calling for economic boycott of certain communities in the aftermath of No Violence in Haryana. Signed by a total 101 female lawyers, the letter petition has urged the Supreme Court to direct the Haryana government to take steps to prevent incidents of hate speech, ban videos of such speech in accordance with law, and take immediate actions against those found responsible for committing such acts. The letter petition also hails the act of suo motu cognizance taken by the Punjab and Haryana High Court with respect to illegal demolitions by the state, calling it an action that builds confidence of citizens in the rule of law. Also, let me tell you, cow vigilante and Bajrang Dal leader Rajkumar alias Bittu Bajrangi, an accused in the recent New communal clashes, was sent to 14-day judicial custody today by a court in Haryana's New district. He was arrested on Tuesday by the state police in connection with the communal clashes that occurred. He has been accused of misbehaving with police officials and spreading violence by giving provocative speeches. In another update, the Supreme Court has referred an important question of law to a larger bench for reconsideration. The court was faced with the question of determining the starting point of limitation for filing an application under Rule 95 Order 21 of CPC. These provisions relate to a situation where property of a person is sold through public auction to satisfy a decree passed by the court. In the present case, the court referred to a coordinate bench decision in Pattam Kader Khan versus Pattam Sardar Khan, which held that it is not necessary for auction purchaser to file sale certificate to apply for delivery of possession. But the court disagreed with such interpretation because Rule 95 clearly states that unless a certificate of sale is granted, the auction purchaser does not get a right to apply for delivery of possession. The court opined that while the law mandates the issuance of a sale certificate, it surprisingly remains silent on a specific time frame within which this certificate must be provided. It observed that in practice there is substantial delay in issuing sale certificates by the executing court. For example, in this case, the delay was of 6 months without any fault of the auction purchaser. The court also found that there was discrepancy between Rule 95 of Order 21 of CPC and Article 134 of the Limitation Act. The Supreme Court bench comprising Justices Abhay S. Oak and Justice Rajesh Bindal has referred the matter to a larger bench. The Supreme Court has allowed certain judicial officers in Kerala to continue in their post despite finding that the process followed by the Kerala High Court in selecting them was illegal and arbitrary. The court noted that 6 years had elapsed since their selection and unseating them would be contrary to public interest. The issue before the bench, comprising CJI Chandrachud, Justice Rishikesh Roy, Justice P.S. Narasimha, Justice Pankaj Mittal and Justice Manoj Mishra, related to the decision taken by the Kerala High Court to fix a cut-off mark on the basis of viva voce for the selection of district judges in March 2017. The Supreme Court noted that cut-off was fixed by the High Court after the conduct of the viva voce, which was manifestly arbitrary. At the same time, in a relief to the petitioners, the court clarified that their failure to get selected will not be treated as a reflection on their merit and that it will not come in their way in future selections. In another update, the Supreme Court has dismissed a public interest litigation that sought directions for mandatory pre-litigation mediation in certain matters such as commercial cases, partition suits and probation petitions. The PIL had also sought for guidelines or a standard operating procedure to give effect to pre-litigation mediation. But the bench, comprising CJI Chandrachud, Justice J.B. Pardiwala and Justice Manoj Mishra, dismissed the PIL and observed that provisions for pre-litigation conciliation and settlement already existed under the Legal Services Authorities Act. The Commercial Courts Act also provides for pre-institution mediation and settlement, and hence there was no requirement for the relief sought to be entertained by the court. The court also noted that the Mediation Bill 2023, which pertains to the issue addressed in the PIL, has already been passed by the Lok Sabha and the Rajya Sabha, and that some reliefs in the PIL were in the legislative domain where court could not exercise jurisdiction. The Kerala High Court today quashed the proceedings against Advocate Sebi Jose, former president of the Kerala High Court Advocates Association, accused of collecting 5 lakh rupees from a client's husband for settling the matrimonial dispute between the parties. The background is that Sebi was representing the wife in a plea for maintenance and for return of her money and gold ornaments. The action against him was initiated after the husband lodged a complaint accusing him of criminal breach of trust, cheating and criminal intimidation. Sebi claimed that the complaint against him was false and baseless and was filed as part of large conspiracy to tarnish his reputation and goodwill. Justice Raja Vijay Raghavan passed the order granting him the relief. Let me also tell you that Sebi is also accused of taking money from clients in the name of bribing judges. He had approached the High Court seeking to quash the FIR in this regard, and the matter is currently pending before another bench in the High Court. Thank you for joining us. If you wish to know more details about the cases I mentioned here, you can visit our website at www.livelaw.in. Stay ahead with quick legal updates only on Live Law. Do not forget to like, share and subscribe and support us.